What happens after a DUI arrest in Illinois? The court process explained. If you've been arrested for DUI in Illinois, you're probably asking a lot of questions. What happens at the first court date? Will you lose your license? Do you have to go to every court appearance? How long will the case take? And is there any chance the DUI can be dismissed or resolved without a conviction? The Illinois DUI process can be confusing because there usually isn't just one case happening. In many situations, there are two separate legal tracks moving forward at the same time. The first is the criminal DUI case in court. The second involves your driving privileges and is handled through the Illinois Secretary of State. Those two cases are related, but they are not the same. One can continue, even if the other has been resolved. Let's walk through what typically happens after a DUI arrest in Illinois. Please note, this video is for educational purposes only and should not be taken as legal advice. If you are arrested for a DUI in IL and don't know what to do next, contact the law office of Dillon Borri to talk with an experienced DUI defense attorney today. The arrest and paperwork. After the arrest, you should receive paperwork explaining the criminal charge, your court date, and any potential consequences involving your driver's license. If you took a chemical test and the result was over the legal limit, or if you refuse testing, you may face what is called a statutory summary suspension. This is an administrative suspension of your driving privileges. It is separate from the criminal DUI charge, and it can begin before a judge decides whether you are guilty. In many cases, the suspension takes effect 46 days after you receive notice. That means you may be dealing with a license suspension while your criminal case is still in the early stages. There may be an opportunity to challenge the suspension by filing a petition to rescind. That petition does not decide whether you are guilty of DUI. Instead, it challenges whether the suspension itself was legally justified. For example, the hearing may involve questions about whether the officer had reasonable grounds for the arrest, whether proper warnings were given, or whether you actually refused the chemical test. There are deadlines involved, so this is something you should address quickly rather than waiting for your first court date. Some first-time offenders may also qualify for a monitoring device driving permit, or MDDP, which generally requires the installation of a breath alcohol ignition interlock device. This may allow eligible drivers to continue driving during the suspension period, but eligibility depends on the specific circumstances. The first court appearance. Your first court appearance is often called an arraignment. At the arraignment, the charge is formally presented, the court addresses your rights, and a plea is entered. Future court dates may also be scheduled. This is usually not the trial, and it does not necessarily mean the judge is going to decide the entire case that day. In many DUI cases, the defense enters a not guilty plea at this stage, so the attorney has time to obtain and review the evidence before making important decisions. The court may also determine whether you have an attorney or whether you qualify for a public defender. You may have to attend some court appearances, but you may not be required to attend every routine status hearing. That depends on the type of hearing, the county where the case is pending, and the judge's requirements. You should never assume that you can skip a court date. Your attorney should tell you exactly when your presence is required. Evidence and discovery. After the first court appearance, the focus usually shifts to the evidence. The prosecution may have police reports, body camera footage, dash camera video, field sobriety test results, preliminary breath test results, blood or breath test records, witness statements, and other documentation connected to the arrest. Your attorney will review that material and look at how the entire encounter developed. Some important questions may include: was there a lawful reason for the traffic stop? Did the officer have reasonable suspicion to investigate a possible DUI? Was there probable cause for the arrest? Were the field sobriety tests administered properly? Were the chemical tests performed correctly? Were the required warnings provided? It is important to understand that the arrest report is only one part of the case. Video footage, testing records, timing, witness accounts, and inconsistencies in the officer's report may all be important. This evidence review is also why you generally should not rush into a plea before your attorney has had an opportunity to investigate the case. Status hearings, motions, and negotiations. Many DUI cases involve several court appearances after the arraignment. These may be called status hearings or pretrial conferences. They give the attorneys and the court an opportunity to discuss the progress of the case, exchange evidence, address motions, and determine whether the case may be resolved without a trial. Your attorney may file motions challenging evidence or asking the court to suppress certain evidence. For example, the defense may challenge the legality of the traffic stop, the basis for the arrest, the way chemical testing was performed, or whether your constitutional rights were violated. At the same time, the defense and prosecution may discuss a possible resolution. Depending on the facts, a case could potentially be dismissed, resolved through a plea agreement, reduced to another charge, or resolved through court supervision if the person qualifies. Court supervision may be available in some first-offense DUI cases. It can allow an eligible person to avoid a formal DUI conviction if all court-ordered conditions are completed. Those conditions may include alcohol education, an evaluation, treatment, community service, a victim impact panel, or compliance with other court requirements. Court supervision is not automatic, and failing to complete the conditions can result in more serious consequences. Trial or final resolution. If the case cannot be resolved through dismissal, supervision, or an agreement, it may proceed to trial. At trial, the state has the burden of proving the DUI charge beyond a reasonable doubt. The prosecution may present testimony from the arresting officer, evidence from field sobriety tests, chemical test results, video footage, and other witnesses. The defense has the opportunity to challenge that evidence, cross-examine witnesses, and present its own evidence when appropriate. If the judge or jury finds the defendant not guilty, the criminal case ends. If there is a conviction, the case moves to sentencing. Sentencing can involve fines, probation, alcohol or drug education, treatment, community service, license consequences, or jail, depending on the circumstances and the person's prior record. A DUI involving prior offenses, a crash, serious injury, or other aggravating factors may carry significantly more serious consequences. What happens after court? Even after the criminal case is over, the license portion of the case may still require additional steps. Depending on what happened, you may need to complete evaluations or treatment, pay reinstatement fees, attend a Secretary of State hearing, provide proof of insurance, or satisfy other requirements before your driving privileges are fully restored. That is why a DUI case does not always end when you leave the courtroom or complete your sentence. The most important thing to remember is that the days and weeks after a DUI arrest can be critical. There may be license deadlines, evidence that needs to be preserved, and decisions that can affect your record and driving privileges for years. If you have been arrested for DUI in Illinois, do not wait until the case is already far along before learning about your options. Contact the Law Office of Dillon Borri for a consultation about your case, your license, and the next steps in the Illinois DUI process.